Well, good morning. Today we have on the table four major legal and constitutional developments with far-reaching implications for Ghana's justice system, for our democracy, and for our economy. These are critical issues we're going to discuss this morning. And I believe, as we normally do on current agenda, we serve it with explanations, we bring it with meaning, with clarifications for you to understand. This morning I'm joined by a team of legal brains to understand and explain into details what the issues are. So we'll start. Now, within the course of the week, the Court of Appeal overturned the conviction and the 10-year custodial sentence handed to the former Chief Executive Officer of Maslock, Sedina Tamaklo Ationu. She's been acquitted and discharged on all charges. Now, the court held that the prosecution failed to prove its case beyond reasonable doubt. The ruling raises fresh questions about the quality of investigations, about our prosecutions, and the practice of trying accused persons in absentia. Then after, we'll turn our attention to what I consider as the most significant constitutional reform proposal since 1992. Now, government, within the course of the week through the Attorney General, has indicated its acceptance to the Constitutional Review Committee's recommendations, one, to extend the tenure of the President and Parliament from 4 years to 5 years. Now, proponents say the extra year will give government some room to implement and properly assess its policies. Critics, however, argue that it would weaken democratic accountability. This morning we ask, is Ghana really ready for a 5-year political cycle? In another landmark decision, the Supreme Court has upheld the constitutionality of the Office of the Special Prosecutor Act, affirming the legal basis of the institution. However, the court also ruled that the Attorney General retains the constitutional authority to discontinue prosecutions initiated by the OSP. Now, does this strengthen checks and balances, or does it undermine the operational independence of the special prosecutor? We'll discuss this with private legal practitioner Noah Damte, who brought the constitutional challenge before the Apex Court. Then finally, we'll finish off with a bit of the politics, where the Ashanti Regional Chairman of the New Patriotic Party, Bernard Entry Boesiaku, popularly known as Chairman Wuntumi, has filed an appeal against his conviction in the Samraboy illegal mining case. He's asking the Court of Appeal to set aside the High Court's judgment. Will this result in another major legal turnaround, or will the conviction still stand? These are the issues on the table this morning. Stay tuned, stay with us as we separate the law from the politics, the facts from the opinion, and examine what these developments mean for Ghana's democracy and justice system. This is Current Agenda, your Saturday morning companion. We'll be right back after this break.
From the heart of Africa we stand, building dreams across the land. Every step we dey your side, helping you rise, taking you higher.
Strong as a group, close as a partner. Bank of Africa lifting you higher. African Bank with global reach. BOA make your future glow. Strong as a group, close as a partner. Bank of Africa lifting you higher. African Bank with global reach. BOA make your future glow.
Africa, as strong as a group, as close as a partner.
Stay back and stay safe. The National Petroleum Authority is cautioning the public to desist from scooping or fetching fuel from overturned fuel tankers at accident scenes. Do not get closer to the scene in an attempt to take videos or pictures. Inhaling the petroleum product is detrimental to your health. Worst of all, petroleum products are volatile and highly flammable, and a small spark can trigger a catastrophic explosion, causing deaths and loss of property. Call the Ghana Fire Service or Ghana Police personnel to handle the scene, or reach the National Petroleum Authority's contact center on 0302 550 380. Your life is worth more than a gallon of fuel. This Save a Life campaign is from the National Petroleum Authority.
Well, welcome back. So this morning on my reflections, I would just do something very short. I would want to focus on this discussion. One of the things that came out of the Constitutional Review Committee's recommendation, the 5-year presidential term, whether it strengthens governance or it weakens accountability. Now, the proposal to extend the tenure of both the president and parliament from 4 years to 5 years is one of the most consequential constitutional debates Ghana has had since 1992. Now, it is not simply about adding an extra year. If you just count it as 1 to 5, it sounds like you're just adding one more year. It is about finding the right balance between effective governance and democratic accountability. Now, on one side of the divide, the argument is that 4 years is too short. It says that a new government, once sworn into office, takes a period of about a year to do its administrative things. Typically, it spends like a period in office forming government, reviewing its policies, and making key appointments. Now, implementation actually for them, for that proponent, is that it picks up in the second year. So it's in the second year. So for instance, President Mahama was sworn in on January 7th. The proponents of this are saying that it will probably take him the whole of 2025 to a bit of 2026 to set his policies, his appointments, and he will take off in 2026. And by the 4th year, attention would ordinarily shift to re-election. And so now the focus is on forming campaign teams, looking for new manifestos. So technically, they have only 2 years. So the result is that they have a limited time to execute long-term national programs. And they believe that a 5-year term supports what they say would allow for a greater policy continuity, and then also the completion of flagship projects. And then it gives them more space to attract long-term investment. They also indicate that it can reduce the cost of conducting elections if it comes that frequently. And so the frequency of elections has now been expanded, and so it frees up public resources. Now that is one side of the argument. A lot of them cite some democracies who operate on a 5-year cycle. Now, and they are asking that Ghana should be another country that should prioritize development over frequent elections. Our focus should not be electoral cycles, but we should focus on development. Now, on the other side of the argument is that we should focus on rather having a stronger democracy. Now, they are saying that democracy rests on accountability. It's when people are accountable. It's when the elections is where citizens have the direct tool of judging their leaders. In other words, if you extend it to 5 years, you've extended the period by which citizens can decide whether a person is good or not. And so extending the tenure simply means that if somebody is underperforming, technically you're giving the person 1 more year to underperform. If the person happens to do 2 tenures, you're giving the person 2 more years to underperform. And he says that this person will stay in office for that long, and the people will be facing underperformance and poor leadership. And the electorates will have no option than to wait. Now, the question I am asking is that in a time where unemployment, in a time where inflation, corruption, and poor service delivery remain pressing concerns, what should be our focus? It's extending the tenure by 1 year. That magic one that automatically will solve the problem. If you extend by 1 year and still we have weak institutions, we still do not appreciate accountability, we still do not appreciate time, we still are corrupt in our minds, what would that additional 1 year really do? What will it do? Now, many view this proposal as weakening the power to hold leaders to account. They see that just this means that, oh, I have to wait 1 more year. 1 more year, a lot of things can happen. And also, it borders on public trust. This extra 1 year borders on public trust. Now, the amendments that affect public tenure are often met with suspicion, even when well-intentioned. And so, if you've listened to the public space, it comes across as if it's being done to the best of the politician rather than the people. People ask about the motive behind this. What really is the issue? If you want to be a president, if you want to come into government, your administration, your policies should be tried and tested even before you are voted into power. During the transition period, you do whatever it is. You should take you a minimum of 4 months to set the ball rolling. If it takes you 1.5 years, really, then you have no business wanting to govern us. So for such a reform to gain legitimacy, it will require a lot of transparency, a lot of broad consultation, and ultimately the approval by the people. Not just the political elite, but by the people. But the deeper question which I have asked Ella perhaps is whether tenure really is the problem. And I'm asking it again. Is the challenge the length of the mandate or the efficiency of the people we put in charge? If somebody is efficient, year 1 you would see, year 2 you would see. You do not need 4 years or 5 years to show that you are efficient. If governance indeed is a continuum, as we have been told, then really it doesn't matter when you start your project. Once it is sound and accepted by the people, the next government who comes will be forced to continue with it. Now, what would an extra year really do? Will it automatically deliver better roads for us? Will it automatically give us stronger institutions? Will it improve our healthcare simply because we have 1 more year? Or will the quality of education become exceptional because we have 1 more year? Should we judge governments on their tenure, or we should judge them on what they have been able to achieve within a short period? Capability is not about time. Capability is how short, no matter how short you have been given, what you can do within that period. So I think the debate should be guided not by political interest, not by partisan advantage, but by the public interest. By all means, if a 5-year term will genuinely improve our governance without weakening accountability, then I am all for it. It should be considered. But if it is just adding 1 more year to it, just increasing the numbers, but nothing else will change, then I stand with the school of thought that thinks that we should stick to our 4 years and rather strengthen our democracy, strengthen our institutions, and strengthen our accountability institutions. This is my take on the position, and I believe that as I have started this, a lot of us will have these discussions in our home, and then together we'll make Ghana the place that we wish it becomes. I'll be right back after the break. Welcome back from the break. Current Agenda is proudly sponsored by Bank of Africa and the NPA. We appreciate our sponsors. In studio with me this morning to discuss the topics as mentioned earlier, to my immediate left, I have Noah Adamte. He's a private legal practitioner. Hello, Noah. How are you doing?
Yeah, I'm good.
Good morning to you. Then next to Noah is His Lordship Justice Isaac Delali Duse. He's a retired appeals court judge. You would understand why we have a retired appeals court judge in here this morning, because we are going to discuss a lot of things at the appeals court. His Lordship, good morning, sir.
Thank you.
You look too young.
Really? Thank you.
Thank you. Right. The next to him is a private legal practitioner, also lawyer Austin Kwabena Braco Powers. Braco, good morning. I hope you're good.
Very good.
Right. And then to my extreme left, I have Honorable Bawa Dua. I've missed him on my set for a bit of time. Honorable.
Yes.
Good morning.
Good morning.
How are you doing?
Cool.
Now people have been asking, where is your Bongo MP? Bongo MP has come.
He's been missing action.
Yeah, Bongo MP has been missing. No, Bongo MP is back. Right. He's a MP for Bongo and also the vice chairman for the
I was
private
busy
members.
working for the constituency. That's my access.
Right. I'm sure they are watching you this morning.
Certainly, of course.
Definitely. Right. Anyway, gentlemen, so we'll start with the Sedina Tamaklo case. But before I do that, we'll do a bit of infographics. We'll go through the chronology of events, then right after that, outcome in studio, so we'll discuss the issues. So as some of us may be aware, between 2013 and 2016, Madam Sedina Tamaklo Ationu served as the Chief Executive Officer of Maslock. She and the operations manager, Daniel Exim, were later accused of misappropriating public funds. Somewhere in January 2023, the High Court, presided over by Justice Ifya Sewa Asari Butche, ordered Ationi's sureties, Alex Mode and Gabivina Tamaklo, to pay $5 million to the state after failing to produce her in court. Then in April 2024, the Financial Economic Court convicted her in absentia on 78 counts, including stealing, causing financial loss to the state, money laundering, and procurement breaches. She was sentenced to 10 years imprisonment with hard labor, and then Daniel Exim was also convicted and sentenced to 5 years imprisonment. Now, in May 2024, she filed a notice of appeal against her conviction. Now, after she filed the notice of appeal, we were told that she traveled. If you can have what happened from 2020, from April, please, if you can have it on the screen. We were told that she traveled out of the country, and because she had been prosecuted or convicted in absentia, the state began the process to bring her back to Ghana. So the extradition process commenced in April 2026. Now, in June 2026, we were told that we were successful with the extradition request, and so the United States were going to bring him. Now, this happens to be the first successful extradition that we have had since 2009. And so we woke up one day and we heard that she had arrived in Accra and was taken into custody by the Ghana Police Service and the Ghana Prison Service to begin serving her sentence. Now, somewhere in between June 9th to 24th, the minority in parliament alleged that she was not formally admitted into any prison. They were asking which prison she was in so that they can go visit and confirm. So somewhere, I think on June 24th, we were told that she is in the custody of the Ghana Prison Service, and that were the exact words used: the custody of the Ghana Prison Service. So people asked that within that 15 days, where exactly was Madam Sedina Tamaklo? Now, because we had heard that there was an appeal, on July 30th, we read in the news and then also saw the ruling that the Court of Appeal unanimously overturned her conviction, acquitting and discharging her on all charges. Now, the three-member panel justices, Emmanuel Ankama, Emmanuel Senyo, Amedahe, and Samuel Obeng ruled that the prosecution failed to prove its case beyond reasonable doubt and criticized the trial court for departing from the constitutional presumption of innocence. And we've also been told that the Attorney General has indicated that it will file an appeal with the Supreme Court. But as it stands today, Madam Sedna Tamaklo has been acquitted and discharged by the Court of Appeal on the 30th of July. Daniel Axim, however, remains on bail pending appeal after the Supreme Court's January 2026 ruling. His appeal is yet to be determined. Now, let's hear the Attorney General as he addressed the issue within the course of the week.
This morning, the Court of Appeal issued a decision unanimously acquitting and discharging Sedina Atienu Tamaklo, who was convicted of various offenses in absentia because, she was standing trial, and in the course of the trial, she sought permission to travel abroad for medical reasons and then remain in the United States for the rest of the trial. The trial court convicted her of the offenses charged, and then an appeal was filed by her lawyers in May 2024. I want this to be made abundantly clear that it was my predecessor who filed the appeal. However, coming into office, I reviewed what was filed, and I directed the Director of Public Prosecutions to file opposing the appeal, because we believe that the High Court judgment had merit. Now, with this judgment, I've also directed the Director of Public Prosecutions to file a notice of appeal and apply for stay of execution, meaning that if the stay is granted, the status quo will prevail until such a time that the Supreme Court has had time to review the appeal and then made a determination. So that is all that I can say for now. I have a soft copy of the judgment. I'm yet to peruse it and then come to a firm conclusion as to what will be our grounds of appeal. But I want to emphasize that I believe that the judgment of the High Court had merit, and that the United States District Court that extradited her to Ghana had a basis for making a determination that she was the proper subject for extradition.
Yes, so you heard the Attorney General speak to or address the situation and tell us where the state currently is. But in studio, I'll start with His Lordship. I said, so when we say somebody has been acquitted and discharged, what exactly does that mean?
The acquittal and a discharge clearly means that no wrongdoing has been found. And looking at what I can see, it is necessary to look at the record of proceeding itself in order to determine whether the position taken by the Court of Appeal is right or wrong. As you said in your introduction, the quality of investigation is very essential to a successful prosecution. If the quality of investigation is porous, obviously the case will fall apart, and you can't blame anybody for it. I've heard comments made by political commentators on this issue, and I want to tell the public that even though the judges are not the best lawyers in this country, and they may not be, but they are the best of the lawyers who decided to become judges. And the appointment of a judge is not by the whim and caprice of any president. They go through processes. They present some of their best judgments for assessments. They write examinations. They attend interviews. All that is done by the Judicial Council. Before the Judicial Council picks and nominates to the president for president's approval. So for me, the president's action in appointing judges is merely ceremonial, because all the shovel and pickers work is done by the Judicial Council. So that lays the foundation to begin with. The charges are here 37 or something. Half of the charges were found to be duplicity, which means that there is no foundation in law for the way the charges were laid. Now, when a charge is found to be duplicitous, it means that it doesn't stand. No matter how much evidence you laid on that charge, you are wasting time. And you know, as I have practiced before, I've been a prosecutor before, and I tell you that the optics of filing several charges makes your work more difficult. If those of us who went to the law school will tell you, put your best foot forward. So if you find somebody has committed about 20 offenses, you choose the best 4 or 5, put it up there, and you are gone. If you charge 78 charges, you may find yourself having to lead evidence with 78 witnesses. Can you imagine how long that is going to take you? Because each charge has to be proved beyond a reasonable doubt. And that's not a small task. Some people believe that criminal practice is the easiest practice. With all due respect, it's not true. It is the most difficult practice, because here you are fighting for the freedom of an individual, not only property, freedom, the liberty of an individual. So, as far as I'm concerned, I've looked at the judgment, and I'm not too sure whether it is wrong, because they are working from the premises which I haven't seen, which is a record of proceedings. The fact that the person is being tried in absentia doesn't mean that you must lose your guard. The standard of proof is still the same. And trial in absentia, for me, looks sometimes like a desperate action by the prosecution. Well, when the person is not present, you are tempted to say, well, okay, this is cheap. You know, it's like a penalty. You think that because there's
no goalkeeper.
there's no goalkeeper, you can just shoot. You can even kick and then hit the bar when there's nobody in the post. So for me, I would advise if it will be taken, the trial in absentia should be taken very, very sparingly, because it makes you lose your guard. It makes you feel that it is easy, even if counsel is present. When one of the first cases I lost in the criminal trial was one in which I raised the issue about duplicity on the charge, and it was quickly amended, and I lost the case. Because then the case, after I raised this successfully, one of the senior counsel told me, "Why did you do that? You know, you just keep quiet. Use it on appeal." And on appeal, there's no way you can claw back what you have lost. So for me, some of the time, it is necessary to allow the state attorneys, who are specialists, who are legal technicians in the field of prosecution, to do most of the work, because the act of prosecution is different from the act of litigation. Right. Even though it's a part of litigation, criminal litigation is a different kettle of fish altogether. So I won't rush to say that the judgments can be defeated or will stand until I see what actually went into the record of proceedings, culminating in the decision that the three learned wise men have.
But it's like when you say duplicity of charges for our viewers, what does it really mean?
It means that there are some things we call ingredients of the offense are not stated in the particulars of offense. You see, in the particulars of offense, you have to identify the individual who has committed the offense, the place the offense was committed, the time the offense was committed, the people with whom he committed the offense and the nature of the offense committed. All these things have to be put in the particulars of the offense. And if one or two of them is missing in the particulars of offense that you charge, there's a duplicitous. Sometimes you repeat the same things and make it look as if the charges are going to kill the accused person. The number of charges laid does not necessarily mean that a conviction can be obtained. The fewer the charges, the stronger the evidence, the better the proof, and beyond reasonable doubt. So, what does the defense counsel do? If the defense counsel tells you that at the time you claim that I was committing the offense, I was not in the area, which is alibi, that's the end of the matter. Right. And all of us must remember that there's a right to silence. The accused person need not say anything at all during the investigation. You cannot force the accused person to say anything during investigation, because there's a right to silence. You are saying that I've committed an offense. Bring all the evidence against me. So if an experienced lawyer has a client who is being investigated, they can just tell him, I reserve my statement for court. Simple. So the investigation has to, you don't expect the accused person to help you to do your investigation. That is why it is always better to investigate discreetly over a long period. And then when you are coming out, you know what you have got. But if you rush, people will take steps to plug the holes. And then eventually you cannot even get the witnesses you want to use. So for me, it suffices to say that it is good to have an appellate system. Right. Mistakes can be made, and the appellate level can correct the mistakes.
Okay. Thank you. Now, Noah, were you surprised to have heard that there already was an appeal to this judgment, that it looked like majority of Ghanaians were even not aware until the AG mentioned that as at the time when she was convicted in 2024, in May, they filed an appeal? Because the discussion so far, extradited, bring her back, there was not a single mention that she had appealed the case.
No, so I wasn't surprised. I'm not surprised because practicing before the Ghanaian courts, I have come to realize that there are a number of times where processes are filed and the public will not know about it, even if it's in a matter that is of public interest. That is one. And also, if you have done cases with the Attorney General has a very weird and extraordinary process by which documents are received at the Attorney General's department. Right? And I've had several instances where I have been frustrated that I have filed a process on behalf of my client. I go to court, and the lawyers representing the state from the Attorney General's department comes to court and say, we have not received it. Why? Because when a document is served to the Attorney General, it goes to a secretariat, they get the stamp it as received, it has to travel through a bureaucratic process till it gets to the Attorney General, and from there it now comes down before it gets to the lawyers on record. So whenever I hear that there is a lawyer for the state who does not know that a process has been filed, I am not quick to assign blame to the lawyers on the other side or even to the state. Because sometimes I know the bureaucratic processes within the Attorney General's department makes it sometimes difficult or even leads to delay in the Attorney General or the people representing the state receiving the process. But then we also have to clear one important issue concerning this issue of whether an appeal was filed. Because we quickly assign political malice to a number of cases that come up, even lawyers, when speaking on issues, are quick to include such innuendos suggesting that the state is in cahoots with the judiciary in some of these issues. But we have to be very cautious about that. One, it is not a duty of the opposing party or counsel to serve a process. Once you file an appeal, it is the duty of the court through its bailiffs and process servers to serve the process on the other party. So the issue is whether or not an appeal was filed in 2024. And the only way you find that is conduct a search at the registry of the court. If you conduct a search at the registry of the High Court that gave the ruling, and an appeal was filed within 2024, it is immaterial that the process was not served on the state, because it's not the duty of the appellant to serve the state, right? So that whole issue of, well, the government or the NDC in power or some political party was trying to hide the process and nothing was said in the extradition process, I don't think it's really consequential. It's possible nothing was said because the state did not know the process had been filed. And it's possible the state did not know because the court registry did not serve. It's also possible they were served, but because of the bureaucratic process in the AG's department did not receive the process on time. So the only way we find that is for a search to be conducted at the court registry to find out whether in 2024 or May of 2024, a process was actually filed called a notice of appeal on behalf of the appellants.
But in your opinion, if the Attorney General knew, would the course of action as has rolled since 2024 been any different?
I don't even think it will be materially different, except on one issue. So if you read the 94-page judgment, the court begins by addressing a preliminary objection, right, which concerns the fact that the Attorney General argued that because Madame Sedina Mationu did not appear for her trial at a point in time, we also need to be very clear on that. When you read the judgment, the court said that she was in court for a long period of time. It was only at a point when she took leave of the court to go and attend, seek medical treatment, and then she didn't come back. So it wasn't as if she wasn't in court throughout. She was in court at a point, even when they were cross-examining the witnesses of the state. But the point is that there is a point where she leaves the country, right? And the state, in that moment, knew that Madame Sedina Mationu was not in the country, right? Now, if at that point, the case has come to an end, and there is an appeal that a notice of appeal has been filed, the question is, in the extradition process, is it incumbent on the state to say that? I don't think so, because whether or not a notice of appeal has been filed or not, it's not going to inure to the interest of the state that wants to extradite the person. So it could even be possible the state knew about it and they didn't see it. But in court, when that preliminary objection was raised that Madame Mationu does not have the right of appeal, remember the court said that the right of appeal is a creation of statute. It's a creation of the Constitution. The Constitution grants her the right. You get that? And so it was the state even raising that issue of whether or not she has a right for an appeal, even in the written submission they filed and not on time, suggested that when the state did not know of the matter, or even if they knew about it, they felt it was not a necessary issue to put in the extradition process. Because you don't want to also raise issues in the US, the judges that will hear the extradition request in their mind that there's even a process in Ghana by which the person is seeking an appeal, because that may lead the court to say, okay, then let's wait, right? So you don't maybe want to introduce that. And so it wouldn't have significantly changed how the extradition process would have gone, and even how the appeal would have been prosecuted. My only challenge is that the state did not raise that issue earlier, and then they made it a preliminary issue before the Court of Appeal. But even if you look at how the Court of Appeal addressed that issue, the court was very charitable, even to the state.
Right. Powers, now we hear duplicity of charges, which His Lordship has mentioned that your case is as good as how the investigation was done. Now, if out of about 74, almost half have issues, does it not speak to how prosecution is done in this country?
This is one of many cases. I'm not sure this is a normal thing for charges to be rendered defective or declared defective. There are so many charges where the prosecution has succeeded. So it is not to say that many of the charges filed or cases brought by the Attorney General or the state had issues with the charges. But you would understand that, as my Lord explained, when it comes to criminal matters, somebody's liberty is at stake. So the Constitution is very clear on that. Now, because somebody's freedom and liberty are at stake, the person need not to be tried just simply. There must be processes that must, or there are processes that must be exhausted. And failing to exhaust that process, even though you may have a legitimate case against a person, you won't succeed. Because the state will always, the constitution will always come in. Because the thing is that when you have to balance the liberty of the individual and that of the state, you go for the liberty of the individual. Because the state is powerful, and the state can bully their way through. So the constitution is very clear on that. But Kojo, the judgment is an interesting one, and I'm sure you've had opportunity to read it. Yeah. One that raises some fundamental political questions, and I've been asking myself after going through the judgment. So the first has to do with whether or not the decision to prosecute Sedina Tamakloe was by a partisan one, or one done in the interest of the country or in the interest of the state. The second question has to do with whether the prosecution truly was in pursuit of justice or it was driven by something else. Then the final political question is whether her conviction was an attempt to execute a political vendetta. Now, my Lord and Noah have evidently pointed out, the thing is that you may have a genuine case, but if you don't prosecute it within the determination, what has been determined, or within the prism of the constitutional framework, you will not succeed. And when you read the judgment, Kojo, you will know that some of the decisions of the law lords or the three wise men were technical, were very technical. So ordinarily, the ordinary Ghanaian in the street would have said, oh, why didn't you allow this to go through? Because they feel that, why not? The state said they have a document evidencing that Sedina Tamakloe acknowledging the receipt of 500,000 cedis from Oba Tampa. So on the basis of that, the state has a legitimate claim. But the Evidence Act is very clinical. Very, very clinical. So before a conviction could be granted, you must have exhausted all the relevant legal framework. So could you understand the criticism out there, and many people are dissatisfied with the judgment of the Court of Appeal. But the thing is that the judges made the decision based on the document before them. They had to review documents. Don't forget that they do not have the benefit of seeing Sedina Tamakloe when she was part of the process in the beginning. So they have to review documents filed by the state. And I understand, because she was tried in absentia, she didn't have the opportunity of challenging some of the assertions. But that is part of the law. Since you brought the charges, you must prove. The thing is that the threshold will not be lowered for you because she was absent. There's no way in the Constitution or any of the statute that says that the threshold should be lowered. That is proof beyond reasonable doubt. Should be lowered because the person decided not to avail herself to the jurisdiction or avail herself to the court. It is still proof beyond reasonable doubt. But Kojo, there are a lot of misconceptions out there, and let me address two of the misconceptions. So there's a claim that the Attorney General, that is the current Attorney General, failed to file a motion or notice for rectification of proceedings. So some people are they are blaming him that there were some evidence, AM1 and 2 and others, which were not brought, which they claim were not brought before the Court of Appeal judges, leading to this decision. But I'm sure they've not checked or gone through the records, because, and I'm sure, Kojo, you have it.
Yeah.
That clearly the Court of Appeal had an opportunity to make a determination on the motion. Because when you look at the court notes dated 28th of May 2026, the Court of Appeal, Quorum, Georgina Mensah, Dache Mrs. J. Emmanuel Senyo Amedahe, and Aiti Ama Tete, had opportunity to make a determination on the motion on notice for restitution. So they claim that the current Attorney General did not bring or did not pursue this case spiritedly based on this front. It's trivial. Most people are not well aware of the record. And again, Koyo, there's a claim that there have been two different panels that had opportunity to hear this matter. And now Maxim said, why is it a problem? They are saying the panel that first sat on the matter is different from the panel that rendered the decision. But is it a problem? What is their problem? The issue is that
Is it the first?
That's how I'm surprised. Because I've had opportunity to file a motion for extension of time. We need to file my statement of case before the Court of Appeal, and it was heard by a different panel. Then the decision was also rendered by a different panel. So I don't understand why people are trying to make a case out of this. Pardon?
So there are different suits, so you can have different.
Exactly.
Yeah.
It's allowed. I mean, the days when one panel will have to handle the entire case is long gone. So a different panel had the opportunity to determine or make a determination on the motion or notice for restitution of records of proceeding. So there is nothing wrong with what is happening. But the judgment in my mind is sound but unsatisfactory, which is why I'm one of those who said that the Attorney General must appeal the decision. Because you see, where you have one court, a trial court, convicting a sentence, and the first appellate court varying the conviction and the sentencing, then you need the Supreme Court. Because I'm saying that we need to bring a definitive conclusion to this matter. This matter should not be left hanging. If indeed the state did not make out its case appropriately, the Supreme Court must have the final determination. We should not take the Court of Appeal. We respect the decision of the Court of Appeal. But I believe that to clear all doubts, because many people believe, and don't forget, Koyo, the emotions out there is different from what the law says. So now when we speak as lawyers, we they feel we are too technical. Because we are dealing with the letter and spirit of the law that had been enacted by our lawmakers. But they believe that we should let their emotions trump over legalism. But that's not the case. Because tomorrow it is today it is somebody else, tomorrow it might be you. So sometimes they should appreciate when we try to delineate between what politics is and what the law is. So, Kojo, the Attorney General has sounded or indicated that he will be appealing. It's a good decision. I commend him because this is one that is in line with the wishes of many Ghanaians. So that the government will not be seem or appear to many people as, like Noah said, be in bed with the judiciary to free certain Natamaklo. Because, it is bizarre. But, the case is messy. Because you are hearing this year, they are here, this year, that year, and people are blaming anybody. But I think we should stop this needless, petty partisan politics. Sometimes, that's why I've always been saying that it's difficult to hear a conversation in this country where you hear one language, the national interest. Every time, my party says this, my party says this, then the national interest is lost in the middle. Let's stop this kind of needless partisan politics. An issue had been rendered by the Court of Appeal. If we disagree, the state says it disagrees, and the state has indicated that it is going to appeal. That is okay, because the state has the power to make decisions on behalf of the people. So let's stop this politics that the current Attorney General did not prosecute this case spiritedly, and that the previous administration. I think it's just messy. Let's make progress.
Right. So I like the preface how the Court of Appeal opened it when he made reference to the Justice of the Supreme Court, Akamba's statement. He says, and you said it rightly, the strength of our criminal justice system over the years has not thrived on mere wishes and speculations, but by the production of evidence that meets the standard of proof of crime in a court of justice. So technically, it's not emotions.
No.
It's not how we wish. Honorable, politicians.
He's a lawyer.
I know. He's a politician. In fact, I'm sure you heard me responding to somebody, which means that Afuakwa has come. He doesn't wait for him to be introduced. Then he just starts. So, viewers, you can see on your screen, lawyer Afuakwa is a member of the MPP legal team. I'll ask you how you are doing. You are late.
Team legal. I'm doing well.
I know you do what you are going to do.
Team legal wife.
He's what?
Team legal.
No,
I'm Team Justice.
On the side of politics. Now, obviously, I'm sure you followed commentaries out there. Those who are not paying attention to the fine details and the cry out there that we said that they would just bring her, hide her in a room, and eventually find a way to free her. Alas, they found a place in law
with McDonald's
to let her do that. How are you, your side of the divide, dealing with this to let the people know that it is not what they are thinking, but it's the law being the law?
Thank you, Gajo. I am very sad about the outcome of this case. Very sad because it appears from the narratives of the facts that some monies might have been lost to the state. It appears. Now, if that is so, how is that supposed to be accounted for? And of course, the persons who are responsible for the loss of the money to the state are the people to be held responsible. How is that to be done? Criminal prosecution is one of them. Now, this is what the state sought to do by prosecuting Sedna and her alleged accomplice. Now, unfortunately, we have arrived at a situation where the Court of Appeal says that that attempted prosecution or that prosecution was not properly done. In fact, if you read the entire judgment, the summary of what the court is saying that the prosecution of Sedna was not properly done at the High Court. And I want to use layman's language, because what we're doing now is educating the public. The Court of Appeal said that they didn't do the prosecution well. You may have a case. You may have some grounds. But the way you have gone about it, it's impossible for you to get the results you seek to achieve. Now that is why when you quoted the very first paragraph of the judgment, the court is saying that the strength of our criminal justice system over the years has not strived on mere wishes and speculations, but by the production of evidence that meets the standard of proof of crime in our courts of justice. So the public having been told that, oh, Sednam has taken so much money, Sednam has caused loss to the state by procuring vehicles which have gone wasted, Sednam has laundered money, or they will be, wow, Sednam must be punished. But you see, so that is the wishes of Ghanaians. And I'm sure the court, the judges also have been hearing this in the media. So they were also surprised that, so what we are hearing, we cannot get it because of what the prosecution has brought. That's why the court talks about mere wishes and speculations. Now, this case has its legalities and its politics. Legalities, you will see that what the judges arrive at, it will be very difficult to say that the judges were wrong, the Court of Appeal judges. Very difficult. One, they say that the charges on causing financial loss and conspiracy to cause financial loss, all those things which have been related thereto, were defective. And they have stated the ingredients that our courts have established over the years as to what should be contained in a charge sheet that we didn't find in the charges that were preferred by the Attorney General then against Sedna. What do you expect the court to do? The court cannot proceed against established legal principles that we have used over the years because we expect that having said Sedna has stolen money and caused financial law, he must go to prison. No, the court must apply the law. So in the application of that law, the court came to the conclusion that those charges were defective and you cannot convict a person, deprive a person of his or her liberty on the basis of defective charges. And let me add that this is not the first time in our courts that a court of law has set aside a judgment on the basis that charges were defective. It is not the first. It will certainly not be the last. So in that respect, the court was not wrong. Now, you go to the other aspect of it, about the substance of the cases regarding stealing and related matters. Like the court said, you can prove these things by way of the evidence. And we have legal ways of producing evidence before the court. If you go contrary, or you fail to apply or satisfy the standards required by law for proving the ingredients of a particular crime, you are not going to succeed. Especially in a criminal trial, where the standard of proof is proof beyond reasonable doubt. Now, you say 500,000 Ghana cedis was received by the appellant, and that there is a note that she wrote to acknowledge receipt. You did not produce the original of it. That is supposed to be an official document. There are legal ways of bringing that evidence before the court, even if you don't have the original document. This, the state, then led by the Attorney General at the time, failed to do. You say that she took money to organize programs and that she didn't give the money to the people who were supposed to benefit. You didn't even call any of those who participated in the event to say whether or not they received the money. There was reasonable doubt. So, insofar as the analysis of the record of proceedings showed that there is doubt in the entire prosecution, conviction of Sedna, the Court of Appeal was entitled to set aside the judgment. And mind you, that at this stage of the proceedings at the Court of Appeal, the court is not calling evidence. The court is relying on the record book. Whatever is in the record book is what must inform the decision of the court, and nothing more.
Right.
And you look at the decision of the court, and it is not an unreasonable decision arising out of the content of the record book, as has been quoted extensively by the court, notwithstanding that we have all not read the record book. You see, the politics of it. There are those who have said that, so the government of John Mahama just brought Sedna in and released it, and that they didn't defend the case at the Court of Appeal well. I think that is an attempt to mislead the public. You know what? This case was strongly fought by the Attorney General Office. They presented a lawyer, a principal state attorney, Hilda Gregg, was the principal state attorney who led the defense of the appeal. Now, She started, first of all, by even raising a legal objection. That Sydenham had run away, so he should not have a right to appeal and all that. Of course, that was thrown out by the court. But there is evidence to show that the state went at every length possible to defend this case. Now, she raised several arguments why Sydenham's conviction should not be overturned. She objected to the argument that no prima facie case had been made before the conviction that the Sydenham's lawyers first put forward by saying that, at that moment, they could not make that argument. She continued to say that even that the accounts contain sufficient information so that Sydenham and her lawyers will know the nature of the case. There were several levels of arguments that the state erected why the court should not free Sydenham, including even that the entire appeal is technical in nature and that the outcome of the prosecution did not occasion a miscarriage of justice. So clearly, this case was fought by the state attorneys. So it cannot be the case that this government did not defend the case well. They did. They did the best they could. What is rather the problem is the mess caused by the then Attorney General in 2024 when they tried the case. The prosecutor said now. They caused a complete mess. First, you crafted charges which were defective. The NDC government was not in office to have crafted the charges. So if the court is attacking the nature of the charges that were brought before the court, who is to be held responsible? It's definitely the persons who crafted the charges. The then Attorney General and the other lawyers at the time. Now, the court is also again saying that the evidence of a letter or a note acknowledging receipt, which was relied on, was not properly put before the court in terms of meeting the standards. Whose duty was it? That is the lawyers, the Attorney General at the time of the trial. The court is also saying that key witnesses, material witnesses, such as those who allegedly took part in the training and did not receive the money, should have been called. Whose duty was it to call those witnesses? The Attorney General at the time. This she failed. So the totality of the case shows clearly that the Attorney General at the time did not properly prosecute this matter. And once that is contained in the record, there is nothing the subsequent Attorney General could have done.
Right.
If the entire proceedings at the time were so murky. So people must understand that this Attorney General is fighting hard to ensure that justice is done in this case. But if in the unlikely event that it doesn't happen, it's the persons who started this prosecution which must be held responsible. In fact, they have caused financial loss to the state.
Thank you.
And should also be held responsible.
Thank you. Lawyer Fokwa, the General Secretary of your party has issued a 3-page letter on this case. A case that was started by you, which Honorable has indicated that you have made it difficult for it to be implemented. Yet you've written a 3-page thesis asking for some members of your party to be released if Madam Sydenham is not convicted.
Let me say a very good morning to yourself and to your guest on your platform. And I'm thankful to God that your table is a table of members of the reading community, and that it is imperative for us to use this platform to orient and educate the good people of this country as far as the clear the clear elements of a failed state being discharged currently as a country. It is where it is today. Could you, upon these happenings, the New Patriotic Party on 6 August 2026, we have served notice to the police. We will be organizing a mammoth demonstration against the undue attack on democracy in our republic. Democracy under attack. You see what politicians cannot do. What politicians cannot do is just to change a male to a female. But all other things are possible.
Now, even politicians are doing that through the LGBT kill bill.
And I'm sorry to say this, that what is playing out to us is a grand set out orchestra performance or choral performance delivered with precision in respect of the Sedinam Ationu Tamakulu skits. Sedina.
I noticed that your general secretary still added an M to the name. Sedina.
We have always pronounced the Sedinam, so I think it's been part of us, and change takes time. So once you have corrected me, Sedina, I know why you are able to pronounce it well. Because you have ties with the Volta region.
Focus.
And I think your wife is taking notice.
Celestial notice.
Celestial notice. Because it is sad that we are where we are today. That the politician has set up the judiciary to be ridiculed. Any appeal on grounds of conviction, against the grounds of conviction and sentencing, amounts to how do you call it? The court has ruled that an appeal challenging conviction and sentencing is by way of rehearing. I think His Lordship is here and will correct us. But once you are challenging the conviction and sentencing, then it means that the appellate court has a jurisdiction, has the opportunity to review the entire record of proceedings to come to a conclusion, whether or not the conviction is sound or founded on law, or whether or not the conviction is not founded on law, which in turn will affect sentencing. I am extremely worried to read out what is playing out today. Madam Sedina was charged with, I think, 78 counts, and her accomplice were charged with our 78 counts of offenses. And indeed, she had opportunity to appear to stand trial, but she waived that right by absconding to the United States of America, and upon which the state continued with the prosecution because she was well aware of the prosecution. So in terms of natural justice, you cannot flout the state in breach of any natural justice principle or rule, because she decided to take a sick leave, permission from the court to travel to seek medical care, and did not return again. What is a worrying trend today is that upon the assumption of office of the Attorney General, Dr. Dominic Ayine, the first week he assumed office, he had some key performance indicators to actualize. And among these key performance indicators were to file nolle prosequis and withdrawals in all ongoing high-profile cases which involved his members of his political party, the political party that brought him into office as Attorney General. As to whether or not the discretion exercised under Article 296 in respect of filing the nolle prosequi, discontinuance and what were withdrawals and all those things were in furtherance of the interests of the Republic of Ghana leaves much to be desired, and it will be determined another day. This is what we are doing to our nation. You remember the Saglemi housing project, $200 million case was discontinued. You remember the case involving Dr. Okuni and Seidu Agongo, similar. You remember, I have a litany of them, I will itemize them. And immediately after that, he pointed a gun at perceived political opponents, persons belonging to the New Patriotic Party. after Operation Clear All Loots, then came Operation Recover All Loots. He came to clear, first week in office, was to clear all his friends, all their brothers, all their sisters who were standing trial in our courts. Why didn't they leave the court to determine all these matters? If indeed those charges were defective, if indeed there were no evidence to support the charges that were leveled against the accused persons that were standing trial, in respect of the former Minister of Finance, Dr. Kwabena Dufour and co. The Ghanaian people are watching the sequence, how the choral performance was set out, and how they are executing that with precision. The difficult task for them to push at the time was the extradition on Madam Sedinam Tamaku, because she had already been convicted and sentenced to 10-year imprisonment, IHL, in hard labor. But having freed all of them, she was the only one standing out, the last woman standing. And what was the method, the modus operandi to get her off the hook? You remember some time ago, the minority organized a press conference and, in fact, gave out a procedure, and that procedure has been succinctly played out with precision.
Martin Kpebu also gave a similar one.
Absolutely. Now, why is she staying abroad? Come, your government is in power. You'll be freed, and those kind of things. It's like what Sammy Jenfi told us prior to 2024, that heads of constitutional bodies should be worried that their tenure of office is coterminous with that of President Akufo-Addo. And indeed, it has played out. You shouldn't take the people of Ghana for granted. Yesterday, whilst on board the flight to Ghana, a foreign national who was seated close to me said something, and I have been worried up to today. Last night.
You were out of the country.
No, just last night. Whether I was in or out on board the flight.
Tell us more. Tell us.
Yeah, you were out of the country. So
no, on board the flight.
M to the name.
On board the flight. Whether
Ghana?
Inbound or outbound flight.
Ghana.
No,
in Ghana.
Please go on.
You see, Ghana is the gateway to West Africa, or Ghana is the gateway to Africa. And in terms of nurturing other democracies, that of how do you call it, Gambia and co. Our justice, our how do you call it, our lawyers, our judges have helped nurture our democracies in Africa to thrive. So once we use politics to set out and set them up in this manner to be ridiculed, as if now the perception out there is that the judges were influenced to render this decision. Meanwhile, if the entire record of proceedings were before them, with the attached evidence, exhibits annexed to it, maybe the decision rendered by the appellate court would have been different. His Lordship is here. They deliver on what is before them by way of rehearing. I am handling an appeal process on robbery. Having filed our written submission, at the time that I was drafting or preparing my written submission in support of the appellant, I realized that some pages of the judgment, the latter part of the judgment, were not part of the record that has been transmitted to the appellate court. So my submission was founded on same and indicated that some of the pages have been omitted to the appellate court. Indeed, the appellate court has directed us to go back to the trial court and get the entire record transmitted back to the appellate court for it to make its determination. By this doing, if same is made, then I need to seek leave to file supplementary submission in respect of the pages that were omitted, in addition to what has already been filed before the court for the court to make its determination on same. So, reading this decision, if an individual who is not politically exposed a matter involving an individual Ghanaian who is not politically exposed, where there were few pages, I think 2 or 3 pages omitted. The appellate court redirected us to go back. And in fact, I wasn't in court the day because I sent an associate to go and represent me because all process had been filed. And the court was to fix a date for ruling. The decision from the AG's office, the state attorney called me that yes, this is the directions of the court, that we go back to the trial court, get the entire record remitted to the appellate court for a decision to be made. Why couldn't the Court of Appeal make such a decision?
No, but counsel, the Court of Appeal did.
Yes.
In this case, because the public is listening, we have to be very.
No, when I'm done.
What record are you referring to?
Yeah.
Even what record?
Because there were just 3 pieces of evidence
exactly.
that were alleged not to be part of the record. Yeah. AM1 and AM2.
Yes.
And a motion was brought for it.
Yes.
The Court of Appeal heard the motion. And even though the Court of Appeal had an issue with the process, the Court of Appeal still granted the motion. And so at the time the Court of Appeal heard the case, the full record of the court was actually before the court. Exactly. So, like what happened in your case, the Court of Appeal actually did that in this particular case. So the full record was before the court. We can't say that portions of it were not transmitted.
Even unless I'm even interested in knowing what evidence he's talking about. Are you referring to the AM1?
So let's look at this scenario again also. When was the appeal filed? We are told the appeal was filed in 2024.
Yes, the appeal was filed
in May.
on the 9th of May.
Who was the appeal served? The notice of appeal served?
I think before you came, I had actually.
You see, there has been a no, not that you have. I heard you. I was listening to you on Radio Ghana in my car, and I heard the litany of excuses that you were giving. That yes, you are handling the matter. And sometimes when you file a process, the bureaucracies at the AG's office and those kind of things. No. I am in several high-profile matters, and all processes that are filed have been responded by the states.
But I think the question is, whose duty is it to serve?
No.
That's it.
No. So it means that the person whose duty is to serve did not serve.
That's the court.
No.
So you can't put the blame on the AG.
No. So the person whose duty is to serve did not serve. So it means that the notice was not properly before the AG. You see, the AG.
No appeal was filed.
You see, the AG, the former AG issued a presser, a 3-page presser, and I think, have you read that presser?
Yes.
Yes. I'll send it to you.
What did you see? That no appeal was
at the time, no. At the time he was in office, no notice of appeal was served on the Attorney General's office. This is a matter of record. He has put it out.
Yeah.
He's a former public how do you call it? Public office holder. He has come out. Former Attorney General, Minister of Justice, whose doorstep the current Attorney General was laying blames to, has come out to rebut him.
When we listen to the current Attorney General, he didn't really blame.
No,
he didn't blame
he blamed him. He mentioned his name, that it happened under his tenure and all those matters. And he says during his tenure, he did not. The AG's office was not served with a notice of appeal in respect of Madam Sedinam Tamakulu's matter. So let us check when service was made, whether there was proof of service, who received the service, at what time. Maybe the same orchestra may play out. Why is it that an appeal was filed in 2024 but was not served on the Attorney General? Look at the duration of time. That even if granted that the bureaucratic tendencies, last time I filed an application at the High Court. I don't want to mention the court. And the judge directed me that I should go and see the Director of Public Prosecution personally on my application, although there was proof of service on the docket. That the Attorney General, no rep from the Attorney General was in court. It was a bail application. That no rep of the Attorney General was in court. So I should go and see the Director of Public Prosecution personally. I went in there, which is not founded in law because the procedure does not prescribe that once a process is filed, you need to go and check. Then I should go to the judge's chamber and check the docket of the judge that the process has been filed on the docket. What is the judge telling me? The only proof is that there should be proof of service on the docket. And the judge, upon second appearance in court, gave us a date. We were in court. He said I should serve the AG with hearing notice and the court notes of the day. I did. There was proof of service on the docket again, second time. for bail pending trial. Second time, I went and the judge says, cancel. I directed you to go and see DPP the last time. Did you do it? I said, yes, my lord, I did it. I had met the DPP's absence. So I spoke with the state attorney. No. I am minded to grant this application. But because they are not here, I can't grant it because if I grant it, sometimes they will come and apply for the order to be rescinded because they were not aware. I said, my lord, this is not founded because the only proof is that there's a proof of service on the docket. And indeed, there's proof of service on the docket. And you know what the judge said? That some of the bailiffs, they don't even go and serve and they will prove service and do. I said, my lord, you have the power to commit them for contempt. If it's indeed established that he did not serve and that he has proved service, it amounts to criminality. So must say, court glorify this act. And you know what? The judge said, that they should rise the court. And upon even telling the court that the decision in Majolabi against Labi stated clearly, the Supreme Court stated clearly, that proof of service is the only proof that the other party has been served. Upon even putting out legal arguments, my court said, ordered the clerk to rise the court. And this is the country we are in today.
Right.
Are you getting it? So the orchestra and what is playing
we are
out.
not in it today. This has been the issue with the ages of
We are. It is playing out today. It is not normal. Why must it be normal?
It's not normal.
Why must it be normal?
But when you are
it is
saying,
not normal. It is abnormal.
The time that
it is not unusual.
And under a government that has reset as a policy, it's not normal. It's abnormal.
But the service was.
It's abnormal.
The process was filed in 2024.
Okay.
The AG's office, the notice was not served on the AG, the former Attorney General.
Okay, gentlemen.
So the presumption, no, I'm coming. You see, there is a presumption that publication coming from statutory bodies are regular. And the AG made a statement, and he's the head of the Attorney General's office, that this started from this side. The other party has come to rebut. So let them come out with clear records that indeed the process. No, I'm coming. That the process were served during the tenure of Godfrey Yebo Adame, and that they were lackadaisical and all those kind of things that they want to play out and shift the blame. The agenda has clearly fallen in water at consume, and that they should hold their head to it.
I just called his lordship, so you need to keep quiet.
And the agenda not to.
You need to keep quiet. Now, listening across the table, I've recorded a bit of a chronology of effect, which for me is a bit worrying. Now, a person is convicted in April 2024. The person says filed a notice of appeal in 2024.
9th May
2024.
Yeah.
Within time.
Yeah. By the criminal matters, no time limits anyway.
Yes.
For appeals.
Always come for.
Without leave.
For appeals.
Now, at the point where the conviction was made and the appeal was made, Sedna was out of the country. However, it took 2 years, because if you check when the appeal itself was filed, it was February 10th, and it was filed on February 12th, 2026. So it took 2 years to file it, and then in 3 months or 4 months after that one, she was extradited, came to Ghana, and then just within a month, acquitted and discharged. For me, if her presence, or because for whatever you have said across the table, during the appeal is just your written statement, blah, blah, blah. All that could have been done within the 2 months or the 2 years. So what was it really that she was sitting and Ghanaians were castigating and calling you if you knew that really there were these technical issues that could set you free and everybody would stop blaming you? Why would it ordinarily take somebody 2 years to come out with something that is on paper 2 years ago?
One major issue is about the volume of the records, and that depends on how fast it was processed. I don't know whether it's 1,000 pages, 2,000 pages. I don't know what it is, but it can be a major factor in determining how fast an appeal is processed. All of us know the records will come and they will be subjected to review. If there are any errors in the records, as it was shown, a proper process will be taken to rectify the records. Appeal can take a very long time, more particularly now that it seems there are no dedicated typists in the system. even though the records are automatically produced, sometimes the quality of the records that are produced from the courts are difficult to understand. I don't know whether it is still the same. Some of the people who type the records don't make any effort at all to understand what is going on. You get the printout and you don't know whether you are in the same court. I think a great effort should be made to produce or train typists who have an understanding of the court process. Copy typists are not helping us in these matters. There are a number of occasions, sometimes even the photocopying of some of the records, the printout is so faint, you can't see it. You know, and then when they are compiling, they don't care. They just put anything in there, and then you go home, you want to peruse the records, and some of them you can't understand. The order is completely changed. So probably, if the volume was great, if you are talking about 78 charges alone could take about 10 pages. You know, and all that. So maybe it is because of the process, and you know, if the processes, the registry shares the records among 3 or 4 typists to produce, it will have speeded matters up. But I would not be surprised if it was only one person who was typing all the records. And as I said, I don't know the volume of the records. The case took about 3 or 4 years to conclude.
It was huge volumes.
Come again?
The volumes were actually very huge.
Yes. So these are some of the things which delay this. And I think the judges...
No, it's mentioned in the judgment. There are about 7 or 9 volumes, actually.
Producing that, you know, photocopying and making sure that the pages, the folios are properly numbered and all those kind of things. It can be and I think the judges, if that is the volume, the judges did a whole lot of work. Before we started, I was telling you that a normal conscientious judge starts the day at 4 a.m. because you have to sit down and read all the records, all the dockets before you read that 20, 25 docket. You have to read it before you go to court. If you don't do it, as soon as they start calling the cases, people like Powers will realize immediately that the judge hasn't read the record for the day. And when we are at the bar, we are doing the same thing. When we find that the judge is not on top of this, and we kick it down on the feet and then we
just laugh.
So I think they did a whole lot of work reading through all those bound volumes, thousands of pages of a record before they came to this conclusion.
Right. Okay. Thank you. Powers. Now, this hits differently for me. If this issue about duplicity, this issue, like Honorable has put, the case was badly put together. If a case can be badly put together, assuming she was in the country, probably she would have been in prison for from that time till now. Does this not go to support the reason why Ken doesn't want to come back? Because if a prosecution can do this, assuming what we are saying, that somebody did a bad work, we'll discuss that case also.
It was decided on the balance of probability.
No, come on now. Does it not go to cement his position?
So just bring that as a second matter. We can put it side by side with this. If you have read the entire
for me, it's worrying.
Bring it up and let's discuss.
With everything I'm hearing, it's worrying. It's as if somebody sets his mind that I want to get you. He can do a bad case, get you, knowing that you can get an appeal. If the case is voluminous, like we said, it can take 4 years for them to finish, and that's when you have your appeal. By that time, 4 years of your life would have been put behind bars.
You will have instances where innocent people have been incarcerated. So many instances where even the Court of Appeal has had opportunity to vary the conviction and sentences, or the Supreme Court has had opportunity to vary the conviction and sentence. So it's not new. In our system, many innocent people are rotting in jail because they have been wrongly incarcerated. And some of them do not have the benefit of getting a lawyer. And those who have lawyers, and like my law said, the system, it takes a while
So you will be in. And if your lawyers, if the judges were not magnanimous or are not magnanimous to grant you bail pending appeal, you will be there. And don't forget that bail is discretionary. So if the judges feel they are inclined to grant it to you graciously, then you walk freely, as is happening in the case of Daniel Zim. Daniel is
on bail.
It's on bail. You get it? So I mean, this is not one of. But let's not lump this issue with that of Ken Ofori-Atta. These are two separate, distinct issues.
No, it's just a state of mind of him not wanting to come back.
So I'm just trying to disabuse the minds of viewers. So as you say, because in fact, when the Court of Appeal rendered its decision, many people will say, "Oh, I've even heard Franklin Cudjoe saying that Ken Ofori-Atta should forever live wherever he is, and that he shouldn't bother coming." But I mean, these are two distinct matters. The thing is that Sedina was tried in absentia. Has Ken been tried? Has Ken been tried?
No.
Yes, it makes it distinct. Sedina had the opportunity to participate in the trial in the beginning, in the early stages. Has Ken responded to the charges?
No, we are aware of.
So these are distinct matters.
No criminal summons have been served.
These are distinct matters. But, Kojo, like I told you, the politics out there is just muddying the whole conversation. And as Noah pointed out, it is never correct. And you see, we need to point out, people who are listening, it's never correct that the record of proceedings were not ratified. I just read to you 28th May 2026, where the Court of Appeal, differently constituted, had to grant a motion or notice. So what is a motion or notice? It means that the other party is aware.
And attended.
Because you have been given an opportunity to defend. The state put in a motion or notice that the record of appeal transmitted to the Court of Appeal had issues. There were some evidence that were not included. So the state took steps to have same rectified. So it is not correct for anybody to put out there that there are some pieces of evidence which were not included in the records of proceeding. And again, to say that the Court of Appeal was not seized with or did not have the opportunity to have the full complement of the evidence before arriving at this decision. Unless they point at any, it will surprise you that the Court of Appeal, if indeed such evidence existed, they would have mentioned it in their judgment. They would have said, as Noah pointed out, the state tried to raise a preliminary objection, raising what they call the refugee doctrine. That because the person ran away, you should not allow her the presence of, or even you should not grace processes, or even have the opportunity to determine an appeal. But the Court of Appeal pointed out that constitutional provisions trump over such common law doctrines. We have a constitution. It says,
Right to fair trial.
Yes, right to fair trial. It's an accused person is innocent until proven guilty. So why are you bringing a common law doctrine when we have a constitutional provision? Don't forget that our constitution is supreme. It has elevated itself among any other individual and institution in this country. So, Kojo, let's not try. This propaganda will not work. You get it? We shouldn't allow this propaganda to fester. The records, as per the judgment of the Court of Appeal, are clear. The records are clear. The judges had the opportunity to look at the evidence. They believe that the state did not put out its best foot. And and Honorable was referencing, when you read the judgment, the judges...
That one for me, so.
Yes, when you read the judges, when you read the judgment, the judges were clear that there were certain key individuals, key witnesses that were not called. If you are claiming that ABC took money or did not give money to B, why won't you call B?
That was a part of the judgment I read. I was surprised.
Yes, why won't you call B?
How do you conclude somebody did not receive the money for the training if the person is not there to?
And you see, funny enough,
you have your time to.
Funny enough, prosecution witness even admitted that they have no grounds to doubt that the event did not even happen. A prosecution witness, during cross-examination, admitted that they had no grounds to believe that the program did not happen, but they believe that the program happened. The person you called.
But that the money was not peace.
And Kojo, let me end on this. See, Kojo, let's be fair with the Court of Appeal judges. Some of the charges brought against Sedina Tamaklo were ridiculous. Ridiculous, absolutely ridiculous. See, you are saying that Sedina Tamaklo entered into an agreement with Mark Autos to procure certain vehicles. And you are saying that the market value of that vehicle were cheaper than the amount quoted. What's that? Contract law. Unless you can prove willful negligence that in contracting with Mark Autos, she deliberately decided to cause loss to the state. But when it comes to contract, if the state offers me this land, GBC, state offers me GBC for maybe 10,000 cedis, and somebody comes and said, the state should have sold it to you maybe for 2 million cedis. Contracts. I entered into a contract with the state.
Has this not been the basis of this whole talk about oral and grabbing land? Because that's what we've been hearing. No, it's not. State land has been sold to people.
Exactly, that's a different conversation, but I'm saying that some of the charges were absolutely ridiculous.
Right.
You see, let's be fair to the judges.
Right. Noah, now we've heard what is happening. As a private legal practitioner, does it give confidence to the general public that, alas, there is fair trial, even if you are convicted wrongly, the appeal court or the Supreme Court can actually come to your aid and set you free?
Yeah, so I think if I'm a private person, I am confident based on this reasoning that there is a justice system that if I am wrongfully convicted, I would have the opportunity to have another day in court before a different panel where the case would now be reviewed and possibly the right thing will be done. But you see, we even as we are thinking of the general public, we have to be very cautious of some things as a country. I find it very worrying that it is now increasingly becoming a campaign promise of all our political parties that we are going to convict people. Right? It is very worrying because criminal prosecution is a difficult thing and it's a painstaking exercise.
The NPP have already promised that tables will turn.
No, so you see, when you set that target for yourself and you don't have an AG or an AG's department that is very meticulous and it's a stickler for process, you are likely to come to power and try to streamroll yourself to get people convicted. And when you read this judgment, that is clearly what you see. You can clearly see, even from the number of counts that were brought, the 78 counts, some of them were not needed even to be on the charge sheet. But politically, it makes sense. If it is out there that as an attorney general, I have brought 78 counts against someone, it sells the politics of it. That's people think the attorney general is doing his or her job. But like I think Powers and then my lord said earlier, when you put such a charge sheet before a court, and you have to prove all 78 counts, and I have to say this even in between this, I was very surprised the court actually convicted Sedina on all 78. Immediately you see that, you should be shocked because it will be very unlikely that all of these charges would actually be established in court. If about 40 of them were even established and a number of them were not, then it to me, it becomes reasonable. But if you look at 78 charges, and all of them actually require you to prove beyond reasonable doubt, then if you take...
I haven't seen the original judgment, but if you are writing the proper judgment, you must state each and every charge and the evidence supporting it and convict on each and every one of them. Did it appear in the original judgment like that?
No, so
or is it a summary of all
no
mixed together?
No.
It's the one I saw. I've seen that one. Every count and
every count was.
Yes.
No, I think my lord is
That's
talking.
a lot of work.
My lord is talking about the High Court.
That's how it was.
That's a normal structure.
Yes.
For each charge, you must state the evidence, the summary of the evidence, and then the conclusion that you arrive at, and the authorities for it. Each and every one, all the 78, all of them.
Yes.
Wow.
No, so
in that one.
So if I'm continuing, you see, one of the reasons why I'm very excited about this particular case, that over the years I've been worried about our courts and even us as lawyers, our fidelity to due process. And when you read this judgment, this is a resounding caution to other courts, other judges, and to legal practitioners that due process is a constitutional right that needs to be protected. For example, one of the things that the courts said in this case, and which I think we have to disabuse our minds on, is the fact that when the prosecution is done with their case, and the court says that there is a case for the accused person to answer, it does not mean the state has proven this case beyond reasonable doubt. It does not mean that. But you see, the conversation out there suggests that if she was not available to lead evidence to raise reasonable doubt, then when the prosecution was done with their case, then it was right that she was convicted. No, the court has increasingly said that when the prosecution is done with their case, the accused person has a number of options available to them. One of them actually includes being silent throughout the trial. And in Kwabena Mensah versus the Republic, the court has said that in such circumstances, the court cannot just convict the accused person because he was silent. You must establish where the evidence on record and come to a conclusion that the case has been established beyond reasonable doubt. And you can clearly tell that because Madam Sedina was not there, it was assumed by the trial court that by reason of her inability or her absence to provide any evidence, and because a case had been made against her warranting her opening her defense, then her guilt had been established beyond reasonable doubt. And that was very problematic, right? And so I would also say that
and you handle that one for me.
Yes. So when you also again read the decision, one of the things that it also tells you is that it is difficult convicting a person in their absence, and prosecutors must actually know that. It's very difficult because as a prosecutor, sometimes whilst you are making your case, we say that cross-examination is for you to also solicit information to help strengthen your case. But when the person is not available and the person has not opened their defense, it is very possible that if some of the piece of evidence you need to make your case very strong is in the testimony they would have provided through your cross-examination, then you are left handicapped. And that is what we see in this matter. Those people were not called to establish their case. The presumption could have been that if Sedina was calling her witnesses, she may have called some of these people, and they would have solicited our information through them. Now she did not call them, and so those holes were then left in the case of the prosecution, and they could not be cured, and the court had to set aside. The
Thank
case.
you. I need to take a quick break. Right after our break, we would we'll use this to dovetail into the next discussion, which is some issues from the review committee, the constitutional review committee, because the issue about that's what I'm saying. We'll dovetail into it, Chairman. Right. So we'll be right back after this break.
Back and stay safe. The National Petroleum Authority is cautioning the public to desist from scooping or fetching fuel from overturned fuel tankers at accident scenes. Do not get closer to the scene in an attempt to take videos or pictures. Inhaling the petroleum product is detrimental to your health. Worst of all, petroleum products are volatile and highly flammable, and a small spark can trigger a catastrophic explosion, causing deaths and loss of property. Call the Ghana Fire Service or Ghana Police personnel to handle the scene, or reach the National Petroleum Authority's contact center on 0302 550 380. Your life is worth more than a gallon of fuel. The Save a Life campaign is from the National Petroleum Authority.
From the heart of Africa we stand, building dreams across the land. Every step we at your side, helping you rise, taking you higher.
Strong as a group, close as a partner. Bank of Africa lifting you higher. African Bank with global reach. BOA make your future glow. Strong as a group, close as a partner. Bank of Africa lifting you higher. African Bank with global reach. BOA make your future glow. BOA, we go there for you night and day. Strong as a group, close as a partner. Bank of Africa lifting you higher.
Bank of Africa, as strong as a group, as close as a partner.
From the heart of Africa we stand, building dreams across the land. Every step we at your side, helping you rise, taking you higher.
Strong as a group, close as a partner. Bank of Africa lifting you higher. African Bank with global reach. BOA make your future glow. Strong as a group, close as a partner. Bank of Africa lifting you higher. African Bank with global reach. BOA make your future glow. BOA, we go there for you night and day. Strong as a group, close as a partner. Bank of Africa lifting you higher.
Bank of Africa, as strong as a group, as close as a partner.
Well, welcome back from the break. Okay. Young man. Welcome back from the break. It's good that you can see us all, so you see the one who is being. See, they can see you on TV. Welcome back from the break. We had a very good discussion at the first part before we went on the break. Before we go ahead, I want to read a few comments from you, then we can zoom in immediately. This person says that looking at the Sedina case, you can all see why it is not prudent to try Ken Ofori-Atta. Okay, in absentia, Kweku Pass. He's explaining that we asking, or those asking, that we should try him in absentia, we don't see reason. This person also says the lawyer sitting there will make a reference to Wuntumi's case, referring to lawyer Afwakwa, because he himself went destroying people's land, blah blah blah. Okay, there he goes, starting with announcing a demonstration. So Afwakwa, when you mentioned that there'll be a demonstration, this viewer is watching us from Dubai. Thank you. He says, until we set an independent body to select our AGs, CJs, judges, IGPs, ECs, and other sensitive holdings, there would always be doubts in every judgment. I'll read two more, then I'll go on. Good morning. Is the MPP saying that the judiciary has been hijacked by the executive without they having any evidence on the contrary to back their perceived wrong judgment? They should tell us where the judges went wrong. The MPP, having influenced judges in the past, are afraid of their own shadows. This is lawyer Alexander Sasutin Crime. Maybe he's using the lawyer as just not to mean what you think it is. So he says a justice of appeal court to appear in a studio is a plus for your program. Thank you. Has the MPP, but anyway, just so you know that he's a retired justice, so he's not a sitting justice. Has the MPP man agree with Honorable Badua's submission or not? I'm sad about the whole judicial system. I'm confused about their actions. Okay. The last one, then we move on quickly. It says that Lawyer Fuakwa is there doing propaganda that Godfrey Dami didn't receive any appeal. He should listen to him, listen to another TV station and hear the truth. I'm not sure how he will listen to another TV station at the same time that he is here. So it can't happen. So please, once you are here, that means you're also not listening to the other station. So it's good that you tune in. Thank you very much. Gentlemen, I know the two of you would want to make a submission. I'll come to you.
We have not.
The reason why everybody was supposed to do 5 minutes, you did 10 minutes. So you actually even did your first and your what shows. You want evidence acting?
Yes. What shows?
I'm the host of the program.
We want to talk about irrelevant things.
Bawa, what is irrelevant? The irrelevant thing is that
you want to go to the
you went to go and produce
Noah. So we'll get Noah, but I'll just give you a minute. Please, let's stick to it, because at 10 o'clock I'm going off for the president he has a program we need to carry live. So 10 o'clock on the dot, whether we are done or not, I'll cut. So or they'll cut me, in fact. So minutes, let's respect it. Then I'll come to Noah straight away. And Honorable, let me start with you. I know you respect the time. The other gentleman, he will do his things.
Thank you, Gojo. I think that the reason for the misconception out there is also partly because Sednam ran away in the course of the trial. And that is making people have this feel, so if she did not do or commit the offenses, why did she run away? You understand? But you see, the legal requirements are completely different from that. I think that the judgment delivered by the court, in my view, meets the standards of law. And I must conclude by
the High Court, you mean?
I'm talking about the Court of Appeal.
Okay.
Setting aside the decision of the High Court. The High Court made assumptions and was clearly misled by the fact that Sedinam was not present, and also got carried away that, if she is not guilty, why did she run away? So the High Court did not take its time to evaluate the evidence that was put before the court as against the principles of law which were required to apply. One of our cardinal principles of criminal justice is that it is better for thousands of guilty people to go scot-free than for one innocent person to be incarcerated. And that is the reason why, where there is some doubt, then the court must hold in favor of the accused person, because you are coming to deprive the person of the liberty of that person. And that's the reason why, in talking about the fact that you would have been in prison for 2 years before your appeal is heard, it is this reason that the court must be cautious. And where it is clear that the evidence is not overwhelming, or does not give you a proof within out of reasonable doubt, then the accused person must be acquitted. So I think that the state, led by Dominic Ayine, should continue to do the appeal, file the appeal. Let us see what the Supreme Court will do in respect of this case.
Right.
Well, it is important that we come to the finality of this matter, so that the public will rest its opinion.
Please take you and do 1 minute too.
Yes, so we in the New Patriotic Party believes that this is a grand orchestra, an agenda of the state, the NDC, to set their own people free. and they have played it out succinctly. Because sometime in 2024, President Mahama, then candidate Mahama, at the NDC conference, lawyers conference in WHO, admonished them that when they win power, they should avail themselves to be appointed as judges. And once that open admonition was made, it is being played out. Certainly, we know what is going on in the judiciary. We know the position of the Attorney General currently. We know what is happening in this country. As far as justice is concerned, the selective application of the laws. We are talking about, how do we call it? Prove beyond reasonable doubt, defective charges, and all those. Look at the Wontumi judgment. We will continue to reference the Wontumi judgment. Look at the Wontumi judgment. And look at the charges preferred against Wontumi and Akonta Mine. Was it sound? And I believe that we have filed a notice of appeal before the three wise men. And if this principle is the holy principle, then we know that no sooner than Wontumi will also come out.
Right.
If indeed true justice is going to be set. Because looking at the Wontumi judgment, if a judge, and I'm happy that my brother Bawa is sounding that it is better to serve, to release or as it were, to grant liberty to 999 criminals than to convict an innocent soul. If the benefits of your word against my word will go to a witness who was an accomplice, that we are told by the Attorney General that the person entered a plea negotiation or a plea bargain and decided to as it were, act as a prosecuting witness for the state, whose testimony without corroboration was the one that the judge held sacred and convicted the accused persons, then there's much to be desired on this.
Right.
Apart from that, there was nothing founded on the record. And we have identified over 12 grounds of appeal. And we have succinctly put same before the appellate court. Succinctly put same before the court.
Right. Thank you.
I believe that if the testimony now, I'm happy that the NDC
what you are doing directly is we have Wontumi challenges the 20th century, but you're already discussing the topic.
We'll come there and open it up.
No, but if you are discussing it now,
correlating with what is happening.
Let me do the correlation.
So, Kojo, with what is happening, Ghanaians are watching.
Right.
And we will demonstrate on Thursday. I have served notice.
Okay.
That we will demonstrate on Thursday because it's part of our democratic tenets and ideals to be able to ensure that democracy lives. They are killing democracy in Ghana.
Thank you. So Noah, you sought some I don't know whether it was interpretation or release from the Supreme Court. Tell us what exactly were you asking and what has been the verdict from the Supreme Court. Then we'll go around the table since you are the man in the center of affairs.
Yeah, so I think somewhere in 2015, 2016, when the former president was campaigning, he made a promise to Ghanaians that he would set up an independent body to prosecute offenses that have political actors as the accused persons or as the principal parties. And that led to the birth of the Office of the Special Prosecutor. And around that time, I have always believed that Article 88 of our Constitution specifically and exclusively centers prosecutorial powers within only the Attorney General. And so the mechanism by which we're creating the OSP was purely unconstitutional. And so early this year, late last year thereabout, that's when I filed this case challenging the independence of the special prosecutor. That is one. That was the main issue. And then several other reliefs contained on the fact that Parliament did not have the power to create an independent prosecutor or to grant some other person some parallel authority to prosecute crimes in this country. And so we went through the proceedings, and I think last Tuesday, the Supreme Court came out with the judgment by which the Supreme Court, in its explicit ruling on that day, stated and agreed with me that all prosecutorial powers in this country is centered in an Attorney General, not even the Attorney General's department, an individual called the Attorney General. And every person who exercises prosecutorial powers in this country does so on the authority of the Attorney General. And by reason of that, you could not create or you could not have a person who is exercising parallel prosecutorial powers with the Attorney General. Now that means that, contrary to the belief out there that the Office of the Special Prosecutor is an independent prosecutorial body, which Parliament itself has touted, the OSP itself has stated on their website that they are independent prosecutor, that is not actually true. And the court then went ahead even to say that when the OSP is prosecuting any case, the Attorney General can file a nolle prosequi, can step in to discontinue the matter. And that's addressed a very critical issue in our criminal justice jurisprudence, because it means that the OSP is now subject to the dictates of the Attorney General. The Attorney General can direct and can decide. And that idea of a potential theft war between the AG and the OSP on whether who can pick up a case, and when one picks up, can the other person go into it? Now we have been able to settle that because the Attorney General now has oversight and supervisory authority over the OSP. But beyond that, there were other orders that reliefs that we sought from the court. And I think because of the way the court explained the relief A, the court then decided that it was going to dismiss the other reliefs. One where we were asking whether Section 3 and Section 4 of the OSP Act purports to confer independent prosecutorial authority on the OSP. The court dismissed that because the court had already held that the OSP cannot exercise any independent prosecutorial power. So I think in a nutshell, that is what that decision means for us as a country. The court has affirmed that the OSP sits within the authorized bodies like YOCO and others that have been authorized to prosecute crimes on behalf of the Attorney General. Just that they are prosecuting some specialized offenses here, offenses involving persons who are exposed politically, and then persons who are also political actors. So that is basically the judgment of the court.
So let me come to Honorable. Now, if you check the Constitutional Review Committee, one of the recommendations that was made, I'm bringing this up because it has a way of tying in with this, where there was a recommendation to have an anti-corruption and ethics commission, where it would be given the sole responsibility to handle corruption-related cases, which means take that case, that aspect from the AG. And in fact, this commission is supposed to be integrated with the OSP and have that solely responsible, have a 10-year tenure. Looking at all this, the reason why OSP was said, some saying that it was said to target the NDC and all that, they did not, or does it not seem reasonable that having this independent body, not bound by the conterminous tenure of any political party, sound like a logical thing to do?
I think that the decision...
I'm putting the two discussions together.
Yes.
So yes.
The decision on the OSP, the authority or constitutionality or otherwise of the OSP, as rendered by the court, was based on the supremacy of the Constitution. The fact that a Constitution has provided that the Attorney General under Article 88 is responsible for prosecution. And yet you have another Act of Parliament purporting to give some prosecutorial independence to the OSP. And whether the OSP was now under the authority of that, and that conflict. I think the court has resolved that. I believe that if the OSP had been an institution set up in the Constitution, as an independent body, separate from the office of the Attorney General for that matter, I'm sure the decision would have been different. So, to the extent that the Constitutional Review Commission is seeking and asking that we set up a similar body in the Constitution, which will specifically deal with corruption and corruption-related, cases, I think that will help, independent of the Attorney General, because whatever it is, the Attorney General and Minister of Justice, is a member of the government, and it's important that there is fairness. Fairness must not only, be done, but it must be seen to be done. So that when you have cases where, you know, the Attorney General has acted in a manner that his party or people in government, among which the Attorney General is, have benefited, then you say that, he's one of them, like my friend Afagwa is arguing now. You understand? But if you have a situation in the Constitution where there's an independent body, irrespective of which government is there, that entity, that government institution will continue to work, investigate corruption, you know, prosecute corrupt officials and all of that. I'm sure that it will help in our fight against corruption. Corruption has brought this country to its knees. Look, you see private individuals putting up mansions and engaging in other things that the state cannot even do. Few years earlier, those people could not have done that. But because they have emerged from public offices, and it's obvious that they made those gains from the occupation of the public offices, and yet the state cannot do much in terms of prosecuting because of the affinity of the officials of the state in respect of these persons. So, an independent institution, provided they decide to work independently. You know, sometimes you can create the institution, but if the persons you put there to operationalize and work for the institution do not decide to do their work well, you come back to the same situation.
Right.
You understand?
Right.
Well, for example, let's look at procurement. You have several laws on procurement framework intended to ensure that, to cut down corruption, you know, especially in the procurement. But what do? Those same laws are abused by the people who apply the laws. So, as a country, we must have a fundamental change of who we are. The reason why the Europeans and the North Americans have succeeded is not just because of the laws, but the ability of the individuals who apply and operationalize the law to do so in good faith. So we need that shift. Otherwise, even if we establish an independent body under the Constitution to fight corruption, we'll come back to the same.
Right, thank you. Afakwa, your side of the divide made a lot of argument when this case was went to the Supreme Court that it's part of the government's ploy to use NOAA to shut down the office of the special prosecutor. In fact, Bravo, if you remember, we even discussed it on this. Yes.
We have
now,
discussed that
from what has been said, obviously there is no attempt to shut down anything. It's clear. OSP can prosecute, Attorney General can prosecute. However, Attorney General can discontinue a case if it thinks whatever reason.
Yeah. So we are grateful to God that on this platform, the discussions we have made on this platform played out in the courts. And this platform, it's a regular platform that the state listens. You see, as a coming event cast its own shadows. It was as a result of my own learned brother Daffy Amapo, whose private members bill motion, or is it a bill or motion to scrap
bill?
Yeah, bill to scrap the office of the special prosecutor. The attempted motion to bill to scrap the office of special prosecutor, that ignited this narrative. That when one of their own was arrested by the OSP, it triggered that kind of agitation, that a former private member's bill was pushed on the floor of Parliament to get the office scrapped. By virtue of this, my learned brother Noah Ephraim Adamte also approached the Apex Court to use the judicial...
No, my case was earlier, before the bill was...
To use the judicial opportunity of seeking the blessing of the Supreme Court to, as it were, to annul the office of the special prosecutor in respect of its constitutionality. But what we said came out to pass, that Section 4.2 of the OSP's Act is in tandem with its function, that formal authorization, because it talks of authorization, that the office is granted authorization to prosecute on corruption-related offences. That it was the Attorney General that sponsored the same bill in Parliament. It was a bill sponsored by the Attorney General in Parliament. And the Attorney General granted formal authorization under Section 4.2. So the mere pronouncement that any other, the Attorney General can grant authorization to other well-meaning state agencies or individuals to prosecute on its behalf is what is captured clearly under the said provision. So we were saying, and I have stated clearly on your platform, that there was nothing wrong with that provision. And indeed, the Supreme Court has given clarity and blessing to that provision that the Office of Special Prosecutor need not any other authorization, because the Section 42 grants the Office of Special Prosecutor the requisite authorization to prosecute.
I don't think that's what the Supreme Court has said. That's what the Supreme Court has
what
said.
did the Supreme
But they're like, the authorization is founded in
They're like, and the court, I think the court referenced Section 42.
Yes,
it was one of his.
Yes, it's reference Section 42.
It was the relief you are seeking.
Yes. So again, but he was contending that provision, the agent needs to grant formal authorization right back and those kind of things.
No.
For each, exactly.
No, that's not what that's not.
That was the impulse of it. Again,
No.
see,
The man is here. You can't.
No. But we are also weighing into the outcome of the court.
No. The person is saying that's not his import, so we can't force the import.
But there's no way that we said that no one can enter nolle prosequi in respect of the AG's prosecution, because the power of nolle prosequi is embedded in the jurisdiction of the AG, and that nowhere in the OSP's Act frowns on the AG entering nolle prosequi or discontinuance whatsoever in respect of prosecutions in the Republic. We have stated that, in fact, the authorization was granted at, is it 883? Was it 883 that granted the authorization to the OSP pursuant to the Section 42? So clearly, we said there was no conflict in that provision. But in as far as rival meanings were ascribed to it, it needed interpretation, and that once it has been to the apex court and the court has given clarity to it, it satisfies the position of the court, the Supreme Court, in respect of the Republic versus the High Court, ex parte Zaneto Ajimai Rawlings and others, where Justice Atuguba stated that where rival meanings are ascribed to a provision of the Constitution, we must stay and refer. Even if it is pending in the court, we must stay and refer, and that anybody can bring an application for that interpretation to
once you cite this one, I know what you want to do.
No. I'm with it. We'll get there. We'll get there.
He knows what he wants to do.
So indeed, we are now certain that the OSP, the Office of the Special Prosecutor, the office has not been thwarted by the effort of other persons, and that the action of DOA has given clarity to whatever it is. And
I mean, it brings finality to whether what the relief sought by NOAA
was granted or not, at least there is a definite position as far as the outcomes are concerned. That gives all of us respite in that the back and forth and the discussions, those for and against, and those things are ceased now.
Right.
In furtherance of it, once there is a white paper and the constitutional review committee or something has made pronouncement, I believe that the government should have also given blessing to all those things so that we can incorporate the Office of Special Prosecutor into the constitutional amendment that we are seeking to do. If government is well intended that we fight corruption and corruption related offenses with an independent ombudsman, so that devoid different from the Attorney General, so that the person will be independent, have how do we call it? Security of tenure. Once you have security of tenure, will not live at the pleasure of any government. That will be able to conduct the affairs of the state, the interests of the state in fighting corruption and corruption-related offenses. I associate myself with the submission made by my learned brother, Honorable Bauer, that corruption is killing this country. We are losing out a lot. Look at His Lordship Dusi, having served and retired at age 70. Maybe the asset that people that enter political office within a year or two have been able to acquire within that short period. He's serving in public office for over 40 years or so, can't even point to a fraction of it. But he has done diligent service to the state. So all these things, we must get a body that will be able to go into this, to be able to, as it were, block the loots, block the leakages and all there is. Look at the Public Procurement Authority, the constitution of the board of the PPA, the Public Procurement Authority. Almost political appointees, and every sole source procurement that goes to PPA gets the board approval. Almost every if it goes first hand and they reject it, it will go second and the third, the same board will approve it. Why did they reject it at the first instance? Why did they reject at the second instance? By the third instance, it was approved. But these are statutory bodies that we have enacted to protect certain procurements and those things. But yet still, it gets the blessing and tacit endorsement because of the nature and the structure of these bodies and those kind of things. Because we don't trust ourselves. Because when giving the black man the opportunity, we abuse, say, then we will continue to put them in our constitution so that it becomes a codified body of laws. In any country that you see a codified constitution as thick as the Bible, then you know that there's no trust in that environment.
I was going to come to you, but let me go to his lordship first, and I'll come.
There's no trust in that environment.
Being a retired judge, I mean, I think it would come to you as comforting to hear that the state wants to have an independent body, which would prosecute corruption-related cases. So now it will not be political handlers in charge of institutions. I don't know what difficulties as a judge probably judges face when they know that the person coming before them is a politically appointed person, and so they try to maneuver their way to make a case. But how do you think this would improve on our fight against corruption?
To be honest, integrity is not a one-time event. Integrity is a continuous life event. And I believe that we need to create a national code of conduct against which performance can be measured. As we speak now, we are talking about corruption and corruption-related offenses. What is corruption? Corruption is misconduct. In any way, teachers are corrupt. Drivers are corrupt. I mean, not all drivers. There are corrupt people within every area. Even pastors have corrupt pastors among them. Those who are supposed to keep the moral compass of the country are also corrupt. The concept of an independent public officer is very difficult to imagine in our circumstances, because if the process of appointment is done by one party in power, then right from the beginning it is moribund. What process are we going to adopt to ensure that the appointment itself will not be subject to political disputes? If anybody can give me a formula by which a person can be appointed and will not have political interference, it's very difficult, because you need a very upright political environment within which somebody can be independent. When the OSP issue was projected, I was one person who believed that it was never going to fly, because the mere concept of a special person appointed with the aim of punishing people in the previous administration. Yes, that was the political propaganda that was going on, that people who were in the previous government had squandered money, they had done that, they had done what, and that this one is coming to arrest and try all of them. And with due respect, up to today, OSP has been in operation for the past 7 or 8 years. What successful case has it prosecuted? I don't know of one yet. So for me, looking at the results, I think that the concept has been defeated. I have been the special prosecutor elsewhere in a different jurisdiction from 30 years ago. I was a special prosecutor for armed robbery cases in Nigeria in the mid-80s. And what was it? This was a simple thing. Senior state attorney assigned to prosecute a certain kind of cases. Period. No special office, no special, but the the Attorney General had determined that all matters concerning armed robbery should be brought to my office, my personal office within the system. No special, no
act, nothing.
No act was yes,
just
yes,
an office dedicated to this.
Yes. So all the brouhaha of establishing an office, investigating, taking over the duties of the police, there is no organization that can be set up in this country which can investigate offenses throughout the length and breadth and depth and height of this country, apart from the police. So, if you want to have, can you have OSP's office, for example, in every district of this country? Imagine the cost. So, for me, the earlier the concept is completely demolished, the better. The police are good. I've worked with the Nigerian police, I've worked with Ghanaian police. If they want to get you, they will get you. If they don't want to get you, they won't get you. Trust me. If Ghana police wants you, they will get you. But because the arms of the Ghana police is long and the fingers are long. OSP, what is it? Very short body. You can't do anything. And if the Nigerians have the special commissioner for corruption, he too has been equally inefficient, ineffective, not inefficient, ineffective. Because you see, corruption is not done in the open. Corruption is always done in the darkness. And those who are doing it in the darkness know who are in the darkness. And if you are not in the darkness, you can't know what is going on.
Right.
So for me, I think that the better the police is fully equipped to do their work
and empowered.
This thing should not be the case. There's even setting up a special court for corruption will not solve the problem if the investigation is not properly done. The court only collates all the evidence and the facts and the rest of it and take a decision on it. But if what is brought before the table of the court is useless, the results will also be useless. Right. So you can't blame the court for this thing. So I believe that strengthening the arms of the education authorities will do a better job. Now we have a lot of people. IOCO can prosecute. OSP can prosecute.
I think Shrash can.
Shrash cannot prosecute. Shrash doesn't prosecute.
But the police itself,
the police
have
can.
prosecutors.
The police have prosecuted GRA. All the divisions of GRA can prosecute. SNIT can prosecute. All these things are there.
Shrash enforce. They enforce their decision.
Come again?
Shrash enforce. They have the power to enforce their decision, but they don't prosecute.
No, they don't prosecute. Shrash can. If they make a finding against you, the court can enforce it, but they don't prosecute. But all this put together,
to the court for enforcement.
A multiplicity of organizations don't contribute to a focused outcome.
Right.
So for me, I would say that if a commission will have to be set up, it means that IOCO will have to be dismantled, OSP will have to be dismantled, and GRA should also be dismantled, because you see, as I said earlier, prosecution is not a child's play that just anybody can get up and say, I'm going to prosecute. Time was when those organizations which had power, which could prosecute, had state attorneys posted to them, seconded. The state attorney is seconded. And then the things went on. But with time, people wanted full power, full control, and then all these things are being carved out for. I don't want to use cronies, but they are being carved out, and then the whole huge office. I don't know whether it is true, but I heard that the current OSP has a bulletproof car. I don't know whether it is true. Yes. When the Attorney General has a bulletproof car, how does the OSP has a bulletproof car? The multiplicity of this thing doesn't create focus. So like maybe I don't know whether we can start having how to call it it doesn't escape my mind. Right. But in the nutshell, if we can have only one body to deal with some of these multiplicity of things, you know, when you talk about the procurement, entity procurement, this, that, tender boss, whatever, the people always wait, create an emergency, and then they do sole sourcing.
Under agency.
Yes. But if we have a proper statistical department in this country, which puts up costs, as is done in England, in the yellow papers, this week, cars are, this kind of car costs so much this week, that car costs so much this week, that, how do you call it, that stationery costs so much, that's called that. So you can't go outside that nationally known price list and go and like the Mark, is it Mark and selling a car at a different price to Maslog and selling it at a different price to the general public. Whose fault?
Whose fault? That remains the question. Always. With this suggestion, I mean, one came to suggest special prosecutor thinking that it will end corruption. Another is suggesting anti-whatever it is. With this continuous suggestion and creating of offices, does it not tell us that, like we say in Chi, AGSM, it looks like we are just struggling to look for whatever it is to hold to, so but there's nobody seems to know what the solution will be.
Well, I think the solution is within reach, and I agree with.
Within reach?
Yes, the solution is within reach. And I agree with my Lord's suggestion. Because the thing is that we have so many state institutions with different focuses. Sometimes they tend to investigate a particular crime. And in the attempt to investigate that crime, they enter into another state institution's jurisdiction or territory. So I agree that we must match all the relevant investigative state institutions with prosecutorial powers so that they can discharge their duties. But as to whether that will be done is another conversation altogether. But let me commend Noah. He did a good job. And I must say, because the decision of the Supreme Court is timely. In one front, it settles or brings finality to the independent status conversation of the OSP. You would notice that the OSP itself has been banditing around that it is independent. But Supreme Court settles the conversation. In fact, the court says the Attorney General has the power to meddle in the prosecutorial duties of the special prosecutor. In other words, the Attorney General can recall the docket and handle a particular matter. You remember that when this kind of issue came up, I said, and people were saying that the OSP is slow. I said that if the OSP is slow, the Attorney General should go for the docket. Yes. Because I was clear in my mind that the OSP over there, as it is presently constituted, is not independent and could not and cannot assume to be independent. And the Supreme Court has sounded the death knell on this conversation. So it is to Noah's credit because it was just speculation. The OSP says, I'm independent, and government institutions as individuals say the OSP is not independent. So the conversation has been settled. And I'm happy for that. So the OSP is not independent. And with this decision, the OSP itself, or the office itself, or the Attorney General, must go to the Court of Appeal and reverse the decision of the High Court. Because the High Court made it, you remember the High Court judge?
Yeah, but the Supreme Court
gave direct
invalid.
Some consequential orders.
Very well. So it terminates it. Yeah.
But before that, they pursue an appeal.
Yeah, sure.
So I'm happy that the Supreme Court has.
But even that decision, it's not really been terminated. Because the Supreme Court is saying that the OSP has authorization through an instrument of authorization.
Yes.
We'll get clarity on that when the full judgment comes out. Because if the Supreme Court agrees that it is through an instrument of authorization, the question will be whether the LI that is in the public domain, that LI actually authorizes the special prosecutor. Because if not, then where is the authorization of the OSP? So that's what also creates an issue. But just to add to the point.
Yeah, so you rightly recall that the Supreme Court held that the Office of Prosecutor Operations Regulation 2018 LI 2374 duly authorizes the special prosecutor. So, Kojo, we are yet, and as Noah admitted, we are yet to see the full judgment. And when we see it, we'll find out whether or not the Supreme Court, in making certain consequential orders, automatically terminate the case before the Court of Appeal.
Right. Because what I have here.
You have the decision.
Yeah, just some narrative. It says that the Supreme Court exercised its consequential jurisdiction to set aside the High Court's decision in Archibald High case as void.
That is good. So, Alice, for me, I'm happy because when the High Court judge made the decision, I was surprised that he did that.
Yes.
But I faulted the OSP because I said there were certain documents the OSP could not adduce before the High Court, and you note even from our discussion throughout this morning regarding Sedina case, if you may have a good case, but if you fail to produce the relevant materials, and because you are mentioning relevant,
yes,
it's not every material.
It's key. Relevant
And
is key.
Kojo, I'm also happy that finally the OSP and the Attorney General will live in harmony.
You hope they will live in harmony.
Though the decision should make them live in harmony. Because animosity between these two institutions
maybe it might not be between the two institutions. Maybe it might be between the two persons.
No, but I will say institutions because they are headed by these people. Honorable.
Yeah.
I'll say the institution.
I agree with you.
I'll say the institution.
It's the way
because
office was set up.
No, I'm not saying the OSP should not go after anybody. That's not what the decision of that is not the decision of the Supreme Court. I'm saying that
they should not go after them.
I'm saying
they will live in harmony.
It's the origin of the OSP which made it think that
exactly. It was the way it was created, and they felt that they could be
fundamental. No law is higher than the Constitution.
Yes.
So if you have a constitutional provision in 88 setting clearly which organization, which body is responsible for provision, any other institution that has been created by an act of parliament purporting that it has independence of opposition certainly cannot survive in the eyes of the constitutional provision in section Article 88.
Thank you.
And the OSP must find a way to
Thank
deal with
and do my prophet no harm.
Thank you.
Because
thank you.
And Kojo, is it just to say that the Supreme Court's decision did not say the OSP should not go after officials of this government? It did not.
No, you are talking about harmony.
But harmony does not extend to that conversation.
No, if you touch them, they will find all the consequences.
Okay, so
but they had the power to
thank you.
That.
We want to say thank you to our viewers also in Monrovia, Liberia. It's Daniel Swari and the rest. So thank you for watching us all the way from Liberia. Honorable, now that you know that if you intend to go the next election, there's a possibility you might go for 5 years instead of 4.
Well, for me,
how many years have we done so far?
Oh, I've done 1.5 years.
Oh, so this what is your first?
First term.
Okay. So now instead of even numbers, the next one you might end up doing odd numbers.
I think that it doesn't really matter. The important thing is what you do with what you have in terms of the duration that you are ruling the country. You can have 10 years. If you don't utilize it effectively, the people who have been suffering under 10 years. So the key thing is how efficient you have managed the resources of the country given the period that the Constitution has given you. So it's not necessarily a question of number of years, but the efficiency of the government in power. at the time.
Right. Afoka, one of the viewers on Facebook says, great submission by lawyer Afoka, incoming MP for Boise East constituency.
Hey, so that's all.
We are also looking at possible 5 years.
Oh, okay. For Boise East.
You can also enjoy 5 years. I mean, I'm reading a comment. That's maybe somebody's prophetic wish.
For the 5-year tenure, I think
you really avoided
the venerable John Agyekum Kufuor, at the time of leaving office, proposed a 5-year term of office for the presidency. He was at the time of leaving office that we should think of extending the term of office of the president, and he did not include that of parliament. But now that the proposal extends to parliament, I think that it is well intended. But this is not the only thing that the people of Ghana need. We need, you see, when the discussion is centered on what benefits the politician in terms of tenure of office, and those without taking into cognizance that benefits the totality of the Ghanaian people, then it seems that we are only interested in, the politician is only interested in protecting its own affairs.
No, but to be fair, if you check the entire CRC report, it's I think it's about a 93-page report. This has just been picked up because, I mean, it stands out. But there are a lot of things, even the local governance.
Have you seen that of the Chief Justice? 10 years.
Yes.
10 years fixed term.
Yes.
Well, we'll come back to that. Then have you checked that of the election of MMDCs?
Yes.
And the deputy MMDCs?
Yes.
What is the purpose of deputy MMDCs? Just to burden the public face. Currently.
No.
No, I'm coming.
The government did not accept that.
The government accepted that.
No, the government accepted the election.
The things that accepted the election, but not the
deputies.
That is good. So, but the elections, have you checked the content of how MMDs are going to be elected?
Yes.
That the party in power does the selection, 3 people, and that kind of stuff. The president appoints 3 people and then push them to the people.
The president appoints 5. And then there is a meritocratic process that sieves out 3.
And that 3 will be voted for by the people.
We are going back to the same soup, because at the end of the day, you are not allowing the people to select. Noah is here very competent. Noah intends to contest for the Accra Mayor, the AMA Chief Executive position, and he's not selected by the president. It means that he cannot go for the election. Then automatically the president must appoint, and don't waste the people's money by running elections which does not intend to benefit the people. You must set out a clear criteria that says that if you want to get to chief executive position, you must be qualified, you must serve in public office, or must attain a certain criteria. Say you might have worked in an administrative position for say 5 years.
The details of
I'm coming. That's my view. It's my view. So don't stop me.
I have to agree with Afuakwa in a way.
Don't push me. That's my view. That open. You know that you are going for an election, and the election requires that you should be an administrator for say a period of say 10 years. Like, we are all lawyers, but senior is over 20 years at the bar. He can be appointed to the Supreme Court. But myself, Noah, cannot be, because we don't qualify in terms of the criteria. So we don't even think or envisage ourselves being in the Supreme Court in the next month. But senior can be appointed to the Supreme Court tomorrow because he's qualified.
As
over 20
justice.
Before you even become a chief justice, you must be a member of the Supreme Court. And he's qualified over 20-something years at the bar. So certainly, once he qualifies, he belongs to that criteria that can put himself out. So once we put this at the doorstep of the politician, then it means that we are going to pick youth organizers, constituency organizers, and those people, select the same partisan people, present them to the good people of Ghana as neutrals, so that they vote on them and come and perpetuate political agenda. If the election is non-partisan, then it means that you must allow the people to select whoever they choose out of the criteria set, so that we can get the best of our people serving in that capacity.
Right.
And again, when you look at other proposals that has come, I believe that we need time to go through.
We look at I think that I can understand the argument is making, but in this country, it's important that central government have some bit of control over who manages the MDC, because the problem is that you have resources largely coming from central government that goes to the districts, the municipalities, for the management of those entities. It is different in other jurisdictions where those
they create their own
funds, they get their own funding, raise their own monies. So you cannot, central government cannot send money to a district.
We are not in a federal state.
Yes, you send money to a district, and yet you do not have some oversight responsibility as to how those monies are being.
But then we shouldn't be talking about decentralization. You see, under the circumstance that Honorable is defining, then we shouldn't be talking about decentralization. We should be talking about devolution.
What's your case on Untumi, the appeal?
Yeah, I'm coming.
Yes,
I'm coming. One central government wants to hold on to the center and decide who goes where, and because resources go to the districts, how much of the resources of the state goes to the districts? Most of the districts are impoverished because they can't even pay services that they have.
Not now.
Oh,
before
now that you are paying
when the NPP was there, that was the situation.
no matter the amount of money that you take to the district, no matter the amount that you take to the district, it cannot provide the people with the social amenities that they deserve.
Lawyer Fogba,
Wontumi, we believe in the grounds of appeal that we have filed before the appellate court, and now that the NDC is schooling us on jurisprudence and the right procedure and a whole lot of things.
The NDC is schooling.
How is the NDC? I'm happy that under the circumstance, for the past few months, the NDC has evolved as the academia in charge of legal training, teaching the Ghanaian people the conditions of bail and the terms of bail, teaching Ghanaian people the procedures eminent as far as criminal procedure is concerned, teaching Ghanaian people how the appellate court exercise their jurisdiction and oversight and a whole lot of stuff, how the Supreme Court conduct its business and those things. I am happy that when you have a country that the majority in Ghana's parliament, the ruling party members now take upon themselves to educate the Ghanaian people on matters of law, due process and those kind of things, then we are developing our jurisprudence. I believe that once they understand the tenets very well, tomorrow when the dawn of accountability opens, once they understand the procedure, they will be able to situate themselves in the same procedure and go through the processes in accordance with the due process that they are teaching all of us. Wontumi has filed through his lawyers over 20 grounds of appeal, and that we are contending that the judgment cannot be supported having regards to the totality of the evidence on record. That's the first ground of appeal. And once we are contending that, a lot of them has been stated on the face of the record, and I must state that I was involved throughout the arrests, the prosecution, up to the latter part of it, and I know what the records of proceedings entails.
In the latter part, when you left the country and came back yesterday?
No, the latter part.
You think you're the only person
No. So I know some people are giving commentaries with regards to the Wontumi matter, but they have not had the opportunity of reading the record of proceedings to apprise themselves of what transpired in court. But they are dwelling the arguments on the decision of the trial high court judge, Her Ladyship Justice Odriko Kuviti J, with respect to her. She has made her determination. She has made her findings. She has exercised her jurisdiction to convict and sentence. As to whether or not her sentence is grounded or founded in law lies within the bosom of the appellate court once we have filed the notice of appeal to review same and to make a determination of same. But we are of the view and we are open. And as far as what we have done is concerned, I can confidently state that the judgment with respect to her was not sound, and that the appellate court exercised their jurisdiction in reviewing same and making a firm determination that will inure to the benefit of the convict, now the appellant, in respect of the matter.
Hold on, 30 seconds.
Yes, I think that Wontumi has a right under the laws of Ghana to appeal. He has exercised that right. I have looked at the grounds of appeal. Given the judgment that was given at the High Court, I am not convinced by the grounds that are contained in that notice of appeal. But I'm not the judge. I will leave it to the judge to decide. If you look at the ground like the court was wrong by lifting the veil of incorporation, we all know that Akonta mining was Wontumi, and Wontumi was Akonta mining. You remember?
How did you know?
You remember Wontumi carried gold?
No, how did you know?
To a TV station.
Well,
and showed the gold publicly. Demonstrated that solid money.
It's an unfair prejudice.
No, let me come.
Let me come.
How is he prejudicing?
How is that?
It's an unfair prejudice.
Wontumi took gold to a TV station.
It's an unfair prejudice.
Everybody saw that. You think that
under those circumstances, the matter before the court is founded on any good that he brought to a TV?
No, he's not determining the case.
Proper corporate governance would not have allowed Wontumi to bring gold.
Wontumi is a private person.
You say that they should not lift the veil of incorporation.
I have never worn a necklace. I don't have one.
But 30 seconds. His microphone is off, so nobody can hear you.
But people enjoy those things.
But Avagwa must give chance. That The thing is that, I mean, it's Muntumi is
Sedinam is okay. Muntumi is not okay. Ghana.
Muntumi is
Nobody said Sedinam is okay. We
Ghana.
say that you did a poor job. That
We are only hoping that they will be able to do a good job.
Right. Thank you.
Happy with the conduct of
Yeah, I think for me, I
did well.
agree with Mafakwa. I agree also with Honorable, and I agree with Powers. To me is a Ghanaian. He has a right of appeal. He's filed a notice of appeal. So let's look forward to what the Court of Appeal will say.
Right. Thank you.
Something happened on the 30th of July.
What happened?
30th of July, former Atuesian was granted bail pending appeal.
Yes.
And on 30th of July 2026, that was 30th of July 2025, and on 30th of July 2026, Madam Sedinam was.
So we wait for
was appointed in
30th
discharge.
of July 2027.
No. No, in respect of, touch
30th
not
July.
my anointed and do my prophets no harm.
Uh-huh.
The prince and
Anyway,
princesses.
thank you
celebrated
very
on
much
30th of July.
for staying with us. Just as he's saying 30th July, 74 charges also seems to be the same number of charges the OSP has brought before the for Ken. So if 30th July is facing 74 also. But thank you very much. Our appreciation to Enoch Afuakwa, a member of the NPP legal team, to Austin Kwabena Bracco Powers, also a legal practitioner, to His Lordship Justice Isaac Delali Dose, retired appeals court judge, to Noah Adamte, a private legal practitioner, and finally Honorable Charles Bawadua, the MP for Bongo and the Vice Chairman of the Private Members Bill Committee in Parliament. And thank you to those who sent messages. The ones that we could not read, please forgive us. But join us same time next week, 7 o'clock, whilst we come to your homes and discuss the issues pertaining. Enjoy the rest of your weekend. Bye-bye.
Was brought to you by Bank of Africa, the African bank with global reach. Bank of Africa, as strong as a group, as close as a partner. And National Petroleum Authority, NPA, where customer care meets excellence.
GBC News, your trusted news channel.
The transportation crisis still persists, with many Ghanaians still waiting in long queues just to get access to public transport, to get to their homes, work, and other places. Currently, I'm standing at the Circle interchange when we have a number of people who are just in queues, just waiting for transport. And as you can see, we have people going to La Paz, we have people going to Teshinua, we have about hundreds of them just waiting for public transportation. We are here to speak to some of them and find out from them their current situation and how they are responding to this particular problem. I have with me here a gentleman to talk to us about the current happenings here. And please, your full name.
Okay, my name is Abraham Jampu, and I live in Abeka.
Okay, so how do you get access to transportation when you're going?
Normally, when we close from work, it's really very difficult for us to get car to wherever we are going to. But in the morning when you are coming to the work, it's so simple for you to get a car. From Abeka to Seko or Accra is so simple to get. But after you are done with whatever you have to do at workplace and then returning back home becomes very difficult. Sometimes you need to fight among yourself and then you see people walking through the window or the glasses or the louvers of the car in order to get a seat and then sit on. And sometimes you may stand here without getting a car. Yesterday, for instance, I closed around 4:40 something, and then when I got here it was 5:18. I stood here for almost 1 hour without getting a car. Looking at how the weather was, something told me to just trek. So I started walking